number 52 in the matter of the Non-Human Rights Project against James J. Breheny, Director of the Bronx Zoo and the Wildlife Conservation Society. Counsel?
Yes. Good afternoon, Your Honors, and may it please the Court, Madam Chief Judge. I represent the petitioner of the Non-Human Rights Project and Happy, a solitary female elephant who has been imprisoned at the Bronx Zoo since 1977. May I please reserve 2 minutes for rebuttal?
2 minutes, Counsel?
Yes, please.
You may.
Thank you. If she hadn't been kidnapped from Thailand as a baby, Happy could be a matriarch herself. But instead of leading her sisters and cousins and grandchildren hundreds of miles through ancient migratory routes.
So counsel, I'm on the screen.
Yes.
Good afternoon. So let's say we accept your argument that habeas turns on the autonomy of the petitioner. So how do we define autonomy for purposes of habeas when it's a non-human, when it's a member of the animal kingdom?
Thank you.
Is that going to be a fact-specific analysis? Do we need consensus in the scientific community? How do we get to that?
Thank you, Your Honor. I'm really glad you asked me that. The scientific understanding of autonomy is basically the same as our general understanding of it, but it's a little bit more complex in that it includes complex cognitive abilities as well as empathetic and emotional capabilities. The experts in this case are unrebutted. There's 5 of the world's most renowned elephant scientists that are in consensus, 5 of them, about Happy's autonomy, as well as the fact that elephants are autonomous. And so as far as what kind of standard to go for going forward, I mean, I think some sort of consensus in the same way you would apply scientific evidence in a human case would be the standard. And again, in a case like this where the evidence is undisputed, I think it's really quite remarkable, which actually was my sort of next point, which is that the scientists are unanimous that elephants aren't just autonomous, but they're also cognitively complex, emotionally intelligent, altruistic, highly communicative, and of course autonomous.
So counsel, let me ask you this. Given that you're not requesting what an incarcerated human might otherwise request, which is sort of release. You want to be released from bondage, released from the unlawful captivity. What you're actually seeking is a different type of captivity, one which you argue, and you have your experts to support that, is better for Happy. But how does habeas apply when what you're simply seeking is a transfer into a different type of captivity under human control?
Yes, Your Honor. 3 things. First of all, these sanctuaries are basically like as if she were being released into the wild. Paws and the Tennessee Elephant Sanctuary are like 2,000 acres. It's sort of hard to conceptualize that, but I live out in Northern California, and you look out and you see hills and hills and hills. The elephants can go anywhere they want to. They obviously can't be released into the wild because that's just not feasible, and that's what the experts are telling us. But habeas corpus has long been used by individuals to either transfer custody. It's used often in child custody cases. The King's Bench issued the first writ of habeas corpus on behalf of a wife, who at the time was considered chattel property, to change her custody to a different non-abusive household. And children were also able to do that under the ancient common law. Also, there is a rich body of precedent for using the writ of habeas corpus in novel situations that go beyond codified law's reach in order to free those who would not have any other remedy at law. So the examples being wives, the children, as well as slaves. There was the famous Lord Mansfield case, Somerset versus Stewart, where Lord Mansfield famously issued the writ of habeas corpus on behalf of James Somerset and freed him pursuant to the writ, despite that.
But even in those examples, they're all human beings. And your point is well taken. I will ask it of your adversary about sort of the status of chattel, even when one is human. But at the end of the day, the court is recognizing the humanity in each of those cases. How can the court apply habeas when we're not talking about a human? How do we make that move from one point of the spectrum to this other point that you're arguing for?
Yes, thank you. Well, Judge Fahey recognized, a member of this court recognized that, a former member, that using species membership, especially in the instance of habeas corpus, where we're seeking one right to bodily liberty under the common law, no other right would flow from that, that using species membership is arbitrary. And there's two strains of common law jurisprudence that render it so. One is the right to bodily liberty jurisprudence, which is broader than just habeas corpus jurisprudence, but habeas corpus is, of course, a subset of bodily liberty rights. And so we have the autonomy cases like Storar and Rivers versus Katz, where the court recognizes autonomy is at the heart of the right to bodily liberty. So we're protecting autonomy. And to say that a being that's like Happy, who is scientifically proven to be as autonomous to us, and we're not talking making basic choices like make a noise or don't make a noise or this food or that food, we're talking extensive communication. Dr. Joyce Poole has identified, I think, something like 200 different words that they're using. I mean, they can have up to 45-minute long kind of like conversations about where we should go. They communicate to convey information to one another, which was kind of news to me because I sort of didn't really understand that when they were talking, like they talk to each other. Oh, maybe we should go this way or this way. So,
Counsel, is it your position that any third party can bring a habeas demanding the release of any animal that has such autonomy or cognitive abilities and demand release to any location of their choosing? Is that your position?
No, Your Honor. To clarify, we are basing our recommendations off of unrefuted scientific experts saying that these are two sanctuaries that Happy would thrive in. There's evidence that other elephants that have been released to these sanctuaries that were considered antisocial and dangerous and, you know, all these things that the second, like within months of being released, were able to flourish as elephants should.
There's not a finding below, there's evidence below, but there's not a factual finding below, and there is contradictory evidence, right? So at most, it seems to me, if we were to rule in your favor, we'd need to send this back for factual determinations, no?
I believe that the trial court did make findings, but of course was bound by the Lavery rulings above, so she was...
Was there a finding in the trial court that Happy, in fact, would be better off in the sanctuary?
Well, the trial court's testimony, yes. I mean, I don't know if you would call it a finding of fact or not, but she definitely said that based off of the unrefuted scientific evidence that that it was, we made it extremely persuasive, was her phrase, case for Happy's release from her lonely 1-acre pen to a 2,300-acre sanctuary. And she continually quoted the scientific record as noting that elephants share a lot of traits that are relevant to habeas corpus, not to other laws, but to habeas corpus for the purpose of the right to bodily liberty.
This line of questioning, counsel, sort of gets back to Judge Rivera's initial question, or maybe her second question, which is, it sounds like we're trading one type of confinement for an arguably better type of confinement, but you've also spent a lot of time talking about liberty. And this doesn't seem exactly like liberty to me. It's just different confinement.
Two things. There's also the prisoner cases. There's Dawson and Johnson, where Judge Fahey also recognized that the cases that Lavery had relied on to say that so there was another case that we filed called Presti, and it was on behalf of a chimpanzee. And in that case, the court said, you know, we actually don't have any issue with the personhood problem. We actually just don't think that there's, that the transfer can be allowed. And so Judge Fahey commented on that and said that our case where we're seeking almost short of complete release, because again, the situation wouldn't be safe for the animals or for humans, to be in an environment that's so close to their natural environment. He said that situation is analogous to the situation in Johnson, where an inmate was allowed to use the writ of habeas corpus to seek something other than complete release.
But counsel, that case, I'm sorry, yeah, that case, Brown, that was a case where somebody was committed to a penal facility, I think it was Attica, and they were transferred to a facility that treated criminally insane at the time, Dannemora. And really the issue there was, could they be held in Dannemora? It really almost didn't matter where they were otherwise, right? The question was, could you commit them? And also, subsequently, the mental hygiene law was changed so they have their own habeas section. So I think the analogy to the mental hygiene law, habeas is a difficult one for you.
Oh, I understand, Your Honor, about the difference between the statutory common law or the statutory habeas. There's still the whole wealth of child custody cases that use habeas corpus regularly to move children from one place to another where they wouldn't be offered complete release.
But is it based on an illegality of the one custody versus another?
Yes, Your Honor, because it goes to the nature of bodily liberty and whether the person who has the autonomy that's, again, like on par with human beings, and I'm not talking Happy is on par with a young child. I mean, the scientists are showing that they are extraordinarily cognitively complex. And so the deprivation of the bodily liberty is being confined in alone and in a 1-acre pen, and we think she's also detained in a barn for a lot of the times when it's cold, because elephants they're not cold, cold-weathered species. So she spends a lot of her time in a barren sort of cell or in a 1-acre pen without another elephant. And even the Bronx Zoo recognized that it's not right to detain an elephant alone. They've decided that they were going to phase out their elephants after, there were less remaining, and then maybe when they were down to 1 or 2, I think they said.
So then is it more like, I'm on the screen, so then is it more like, or it begins to sound like the incarcerated individual who's held in the special housing unit and wants to be in the general population?
No, Your Honor, because this is still, first of all, Happy's innocent, and she didn't commit any crime. But also, again, there is the precedent for using the habeas corpus, it goes back to antiquity, and it's a unique remedy that provides a relief for someone whose bodily autonomy is being infringed upon. And there's no question, at least based on the 5 unrebutted scientific expert reports, that this is no place for an elephant, and these 2 sanctuaries would be as close to freeing her as possible. And so from a legal standpoint, if it would make a difference if she was completely set free or not.
So does that mean that I couldn't keep a dog? I mean, dogs can memorize words, and I think most people who have dogs or any kind of domesticated pet that way would say that they feel there's a special connection and a bond. They're like their family, as I think you pointed out in the brief. If I had a dog, I could leave property to them. So why isn't then what you're arguing for endangering these kinds of human-animal relationships?
Well, we don't have the evidence about dogs that we have about elephants right now, and I don't know when or if we ever will. What we have about elephants right here, right now, is an extraordinary consensus among the scientific community. We also have experts from law and philosophy and religion and ethics, all remarkably on the side of Happy's freedom, including, again, like lawyers who understand that this is...
So are you arguing that deciding this case strictly based upon Happy and not consideration of other different animals is what's appropriate here?
Absolutely, Your Honor. I think that is exactly what the common law requires, as this court recently ruled in the Green case, that the court can take a case-by-case approach using the common law. That's actually the point of the common law. It's flexible, adaptable, and grows with the changing needs of society.
As a follow-up to that, is this case about Happy one exceptionally autonomous and intelligent creature, or is this about all Asian elephants or all elephants? What's the scope of the population we're talking about here?
Well, it would be disingenuous to not think that this would, be precedent for another elephant. It certainly wouldn't automatically free other elephants, but the science is clear about elephants having this autonomy, and it's not just Asian elephants. They're both African and Asian elephants. The science is proving that they're extraordinarily cognitively complex with advanced analytic abilities that, I'm sorry, I don't know if dogs have these analytic abilities. I love dogs, but this is extraordinary science. So I wouldn't say that it's for Happy specifically, but certainly Happy's situation and the deprivation of her unique bodily liberty, being alone in upstate New York or in New York in general, is no place for an elephant. And
what about primates? That's a group that you've represented before. Would they be covered under this decision, or is that another future case?
Every case would be a future case because the common law, again, especially with habeas corpus, is case by case by case. With respect to the science of chimpanzees, I think that they would probably fit this scientific, unrebutted scientific, comprehensive understanding of of autonomy, which includes these cognitively complex components. But as far as we know, I think it's only chimpanzees and elephants that, for instance, mourn and do, grieving behaviors that are akin to humans. So if you look at the science, which I think is actually really just unique and exciting kind of in its own right, like elephants do, like high-five each other after they drive off a enemy, or they do like a halftime football kind of dance. I mean, they're just really special, unique species.
But counsel, it does seem, back on the screen, it does seem now with what you were just saying, that in part you're arguing it's the scientific consensus around these qualities as you've defined them about autonomy that can be scientifically established through a fact-finding process. And your argument is happy, and perhaps all other elephants fit that, but at a minimum happy. But it sounds like you're saying, and then of course, it's the nature of the confinement, because you're looking for one human-controlled environment to another. Although I understand your point that the other, the sanctuary, is one that is as close as, it seems to me you're arguing, is as close as humanly possible in this moment to the wild, versus the zoo is clearly not. So it sounds to me like you're saying it's this combination. Whereas, let's say if the zoo, maybe had an environment that was a closer call about whether or not Happy, let's say Happy isn't isolated. Let's say there's much more land for Happy to travel, or something else. It sounds to me like you think that that is also what, I'm just thinking of how these habeas petitions would work and what a court would have to do, right? The mental exercise. That it sounds like the court would have to figure out this autonomy piece and the nature of the confinement, because it's not pure release in that sense.
Perhaps so, Your Honor, but I want to reiterate that Judge Allison Tuitt at the court below had no difficulty understanding the science. It's throughout her opinion, and also that she felt pretty much prepared to rule in our favor, but for the two Lavery decisions that clearly need to be overturned, by the way, because they establish that to have rights, you need to have duties and to be human. And that's not even the sources that the Lavery cases relied upon were not even supporting the conclusion. For instance, they rely on John Salmon's jurisprudence that says rights, like to be a person, you have rights or duties, and they said and. So we actually had Black's Law Dictionary change the typo so we could maybe not have our case get thrown out again. But the more important point is that the lower courts, the Lavery courts started at the wrong place, which was at personhood. And Article 70 is a procedural statute only, the CPLR. So the legislature intended to leave it to the courts to decide substantive habeas corpus matters. And so the proper place, as Judge Fahey recognized, isn't with the definition of person, which is a backwards-looking, statutory interpretation device, but to look at forward-thinking common law principles and focusing on the right at issue. And when we look at the right at issue, which is the right to bodily liberty, which protects autonomy, and Happy is autonomous by scientific proof, she should at a minimum have the same right as a similarly situated individual that also has autonomy. Because
Thank you, counsel.
Thank you.
Counsel?
Thank you, Your Honor. May it please the court, Ken Manning, on behalf of the Wildlife Conservation Society, the Bronx Zoo, and Mr. James Breheny. This oral argument bears little relationship to the arguments in the court below, in the trial court, or in the appellate division. If I could suggest, the petition says that the petitioner's relief requested turns on whether Happy is determined to be a legal person entitled to invoke the habeas corpus remedy. You've listened now to argument that doesn't even address that point. Whether or not Happy is a person was decided in some respects by the Elephant Protection Act, which was enacted, it was approved before Judge Fahey's concurring opinion, but effective after his opinion, and it deals specifically with elephants.
Well, but counsel, if I can interrupt you here.
Yes, Your Honor.
I understand you referred to this certainly in the briefing about sort of the legislature stepping in to protect. No one is going to disagree with some legislative power to be able to make those kinds of policy decisions. The question is whether or not the Great Writ, the writ that's a common law writ, which is separate and apart from what the legislature may do, could be, because it's flexible, given the values behind the Great Writ, could be now applied to Happy's situation. And they've argued it's autonomy. I think I disagree with what you've started out with. I do think that they're very clear that they say the reason that Happy can proceed and be considered for habeas relief is because Happy is autonomous. You may see it differently, but that's their argument. But why don't you address why, given that habeas is and has been used and applied to chattel and to those who do not have full rights and duties under our system of law, why Happy shouldn't be able to seek a remedy through the vehicle of the habeas writ?
Well, there's two things I would say, Your Honor, and thank you for the question. First of all, the definition of autonomy that we heard today at oral argument is different from anything we've seen before, first of all. Autonomy doesn't mean whatever someone thinks it should mean. There should be some form of definition or determination in terms of what standard we're looking at. This case came up on a motion to dismiss the petition. There was no evidentiary hearing. The court below found two things. One is that Happy was not a person, and secondly, there was no illegal detainment. And if I could address, Judge Rivera, your point on the habeas remedy, there's got to be an illegal detainment in order for the remedy to even apply at all, whether it be a chattel, a child, or a person. And here there's been no illegal detainment. The Elephant Protection Act in particular, specifically by its terms, defines elephants as elephants part of the species, and it defines persons subject to the Elephant Protection Act as individuals, human beings. If the legislature had determined something else, it simply would have done so. So from a standpoint of the Bronx Zoo, there's absolutely no illegality whatsoever. And in fact, if I could go back to the...
Yeah, but if I can interrupt you there, of course, their argument, which is backed up by their experts, again, you may disagree. It's just the nature of the factual record that they attempted to develop, even on the motion. Their argument is that the current detainment is absolutely contrary and unnatural to who Happy is, to this species, and that's what makes it an unlawful detainment.
Your Honor, the petition, quoting from paragraph 56 of the petition, says this petition does not allege that Happy is illegally confined because she is kept in unsuitable conditions, nor does it seek improved welfare for Happy. If that's the case, why would the habeas corpus remedy apply in the first place? She's perfectly legally detained where she is now, authorized by the legislature. There's no illegal detainment, and they're not seeking either better welfare for the elephant, at least according to the pleadings, or...
Well, I don't see how that's I'll ask her. I don't see how that's the argument. The whole argument is that Happy is in an environment that is unnatural to her and harmful to her, and she can't be released given, I wanted to ask you about that, given the nature of this custody that she's been under for decades, that she can't go back to the wild, so the next best thing is this sanctuary.
Well, if I could address the sanctuary, and then I'll take the first part of your question, Your Honor.
Yeah.
The sanctuary, there's two choices here. Basically, the habeas petition here says, let us decide what to do with this elephant. We got a place in California we like, and we got a place in Tennessee we like. You can search the record for any indication in terms of what the Tennessee facility is comprised of or information. It's simply not there. So one of the two picks isn't even supported in the record. So from our perspective, the court shouldn't be in a position to simply take that on.
Mm-hmm.
You know, this is an area, the animals that are kept in zoos are highly regulated. You know, the Association of Zoos and Aquariums has a chapter on elephant care. It's all in the record. I forget how many pages, it's 40 or 50 pages. It's so detailed as to deal with foot care. And to take a case that basically, as I mentioned from paragraph 56, had nothing to do with improved welfare for Happy and now turn it into basically a best interest case like we might for a child in a family court proceeding is well beyond a habeas corpus remedy at this point. So from our...
Yeah, but it doesn't habeas apply, I mean, even a gilded cage is still a cage, right? Wouldn't the habeas apply, let's say someone is incarcerated, if they're incarcerated wrongfully so, no matter how lovely the setting?
I'm sorry, Judge, could you repeat that? I didn't hear the whole thing.
I was saying, no matter how comfortable the setting, if one is wrongfully detained, right? My question was about someone who's incarcerated, is wrongfully detained, no matter how wonderful the setting, the conditions, it's still, as I was saying, a gilded cage. Your liberty is being restrained.
The assumption in your question that we take issue with, Your Honor, is whether they're illegally detained. There's absolutely
No, I understand that. That was your first point. But do you agree with me that to this extent, we'll ask her when she gets back up on her rebuttal, to the extent that there's an argument that it's an unlawful detention for whatever basis she's arguing, the fact that the Bronx Zoo and you all may believe that you've provided a wonderful environment for Happy is beside the point.
Well, we have 3 affidavits, Your Honor, from the chief veterinarian, from the curator, and from the director of the zoo, attesting based on personal knowledge to the conditions of Happy the elephant. I think it's significant in this case that the so-called experts that have offered opinions have never even been to see Happy. They didn't ask to see her. They didn't ask to examine her. They didn't ask to come look at her. They didn't seek a court order granting discovery. They submitted affidavits that were used in another case in Connecticut, Cookie Cutter, to support this application. It was only when we challenged that there was a supplemental affidavit making certain judgments about the animal based on a ride on the tram that goes through the zoo. So there was no interest was taken in this particular animal.
Well, do you disagree that Happy is isolated by herself in whatever it is, half an acre, an acre? You don't disagree with that?
I do. She's not isolated. There are 2 elephants there. The reason they're separated is because they didn't get along.
So let me ask you this, sorry, over here. In the
Yes,
case
Judge.
of Tommy and Kiko, which I realize is behind us and it's not your case, would you also say there that habeas would not have been available because the chimpanzees were not illegally detained?
I didn't, forgive me, Your Honor, I don't think I heard the whole question.
Sure. You're familiar, I think, a little bit at least, with the case involving Tommy and Kiko, the
Oh, yes, of
chimpanzees?
course, of
Right.
course.
So would you say that habeas was not available to them there because they were not being illegally detained?
If they were not being illegally...
No, I'm
detained-
asking you whether your view is they were being illegally detained or not.
Well, I think with Tommy and Kiko case, there was questions about the suitability of their conditions.
Correct.
I don't remember well enough from the record in that case whether there was a finding of illegality or not, but if they were kept in unsuitable conditions and it violated the Animal Welfare Act or the state statute involving animal cruelty, then they would be being illegally detained at that
And
point.
therefore, you would conclude in that circumstance habeas could reach them?
At least that element of habeas, Your Honor, but our premise is fundamentally a very simple one, and that is that historically animals have not been the subject of habeas corpus relief. All the definitional requirements that exist, including the Agriculture and Markets Law, the Penal Law, the Elephant Protection Act, and also the Estates Powers and Trust Law, all of them have definitional phrases dealing with animals and people that would be completely inconsistent with labeling an elephant a person for habeas corpus relief. And if the court were to grant a petition like this, the impact this would have on other statutes and other rights of other people would be tremendous. And it's outlined in the amicus briefs from Protect the Harvest, the researchers, the Farm Bureau. All the amicus show the dramatic impact this could have on our society. And if there's going to be an entire rewrite and a granting of animals to rights that they've never had before, shouldn't that be done by the legislature as the appellate?
But wasn't that also, counsel, wasn't that also the case for the examples your adversary has used where there were chattel, whether it's women or slaves or indentured servants, I mean, or children? I mean, isn't a decision from the court about an expansion of something like the Great Writ always going to have ripple effects moving forward?
I wouldn't call this a ripple, Your Honor. To take animals that have never been subject to rights of people given the social compact that forms the basis for our federal and state constitutions and all the laws that we promulgate to effectuate those two documents, it puts them in the same category as people, which we oppose.
Well, I don't think she was saying that she said that happy was not equated with a child. I don't think they're saying that the elephants and happy in particular are the same as human beings. It's simply to what extent there are rights that can be protected and recognized through the remedy of the writ, right? It's sort of they claim there's an injustice, there's a harm caused by a human action, and that the only remedy available to happy is through habeas, and they simply wish to have their case heard in that way.
There's no harm alleged in the petition, Your Honor. We've referenced paragraph 56 of the petition. No one's claiming any harm to this animal. There's been no harm to the animal, and you have 3 affidavits from the people at the zoo attesting to that. The animal is treated well. She's adapted well to her surroundings, and at this stage, to try to compare this to a case where there's been some form of animal welfare violation would be completely outside the record and inconsistent with this record.
Thank you, counsel.
Thank you.
Counsel, what about the potential impact your colleague referenced here to the other industries, the agricultural, marketing industry, the biomedical researchers, even pet ownership?
Thank you, Your Honor. Yeah, there's no connection between those industries and Happy's illegal detention. Again, with the science being unrefuted, we don't have that evidence, and there's no purpose for Happy to just sit there. They don't even want to keep the elephants there. Notably, the Bronx Zoo has highly accredited elephant scientists. Dr. Joyce Poole testified that they actually have elephant scientists that are real scientists, and they didn't provide any testimony.
Your mention of purpose, I think, it goes back to the Chief's question. Are you admitting that there could be purposes, not for a Happy, but for other sorts of animals, that have to be weighed against whatever the liberty interest we might recognize is?
Your Honor, it's difficult for me to, assign certain, values to these things,
Well, it would be
because they're
difficult
so
for
outside of our case.
difficult for anybody to assign values. My question is whether you're arguing about the recognition of rights of animals allows for some balancing of those rights against some other societal values. So for a simple example, somebody uses a horse for transportation. If the horse crosses the autonomy threshold, under your theory, we recognize the right of that horse to some form of liberty. Is that absolute, inviolate, or can it be balanced against the person's need for transportation?
I think I would refer the court perhaps to one of the amicus briefs. The religious amicus briefs were really great. The Jewish brief talked about how Torah law, for instance, I know that the court shouldn't, I'm actually a church-state litigator, so don't take the religion into the law,
So
but
how about Professor Singer's brief instead, which sort of proposes a utilitarian view of this? He calls it consequentialist.
That could be a good example. The common law allows for some flexibility and for some balancing of the different factors, and here the balance is just so heavily skewed on our side. The illegality, I need to point out, is the common law. In Somerset's case, in Lemon, this court relied and adopted Somerset. It was a pure common law. The illegality was the absence of positive law. And the examples I gave of the King's Bench issuing writs for women, those were all just pure common law. The violation was the common law, which is an independent body of law that the court is duty-bound to upkeep with the wisdom, ethics, and science of the time. And all of that, again, points in favor of Happy because there's no basis to treat her differently from another being that's similarly situated.
Thank you, counsel.
He says there's no harm. He says you haven't argued any harm. And if there was, that falls under the rubric of the animal welfare legislative structure.
We've never conceded that there isn't any harm. In fact, all of this evidence is showing there's an immense amount of suffering and harm, but we are not bringing a welfare case because we don't want Happy. It's not about improving the conditions at the Bronx Zoo. That's not possible because you can't fit another elephant in there. The reason why the elephants attacked each other is because you put 4 elephants into a pen, And Happy and Patty do not get along right now, but maybe they could at a sanctuary. There's evidence in the record of Joyce Poole talking about how this is just too small of space for elephants, so it wouldn't be reasonable to put two people in a too small of a space and expect them to get along. But they also attacked her family. Grumpy was an elephant that was attacked by Patty and Maxine, and so now they're separated by a fence, they are both alone, and they both deserve better, and the common law would allow for it. The court has the authority and the power to grant Happy the freedom that she really deserves.
Thank you, counsel.
Thank you very much.
You're welcome.